So Alice is from the American Payroll Association, and she's going to be walking through her slides about child support and the impacts on the payroll. Alice, take it away.
Thank you, and good morning. So thanks to New York, both the city and the state, for putting on this conference. As you mentioned in your opening, the importance of payroll professionals and employers in the child support program is critical. But I wanted to provide this morning just kind of a management overview of what's going on in the world of child support. And just to mention that each of us plays a role in the child support program. None of us work in a vacuum. So payroll professionals, you're partnered with your employers, with state and local child support agencies, and of course, the payroll org that I work for. So thank you for attending this webinar. And let's see. There we go. So as mentioned, I'm Alice Jacobson. I'm the Director of Government Relations for Payroll Org, formerly American Payroll Association. And one of my roles is helping payroll professionals like yourselves make connections with government entities for compliance and to make improvements for processes and procedures for child support. Payroll professionals continue to partner with state child support directors and the Federal Office of Child Support Services to share information. Monthly virtual meetings have been arranged through the National Council of Child Support Directors, of which New York's Deputy Commissioner of Child Support Services, Eileen Stack, is now president. Our work led to OCSS creating a new communication center with enhanced features. Stakeholders requested improvements to OCSS's information exchange process. So now employers can communicate with child support agencies on the portal using the new communication center, which can speed up the payroll processing and simplify secure information exchange. To access the portal, you must be registered. New users can register online and contact the OCSS for more information at employerportal@acf.hhs.gov. That's employerportal@acf.hhs.gov. Or you can contact the Employer Services team at employerservices@acf.hhs.gov with questions. If you're using a third party to manage child support, such as a payroll service provider, you must add them to your communication profile preferences, or they will not have access. To date, more than 35 states and 5 tribes are using the Communication Center, and all states and territories use the child support portal. Our hope is to have all states and employers using the system to create one process of communication. There we go. One area of success for the collaboration work group and payroll org members is verification of employment for child support. We created a standard form that has been accepted for use in all states and territories. The form does not replace state VOE requirements, but in most cases, the form will provide a state with the answers needed to process a child support order. And that way you can automate your process. You can find the form on the Federal Office of Child Support Services website, which is listed on this slide. Several years ago, the collaborative group developed model legislation on lump sum payments. The model could also be used to develop or improve state regulations. This brings us to what's happening at the state level. 25 states, including New York, have lump sum payment requirements for child support. Some state legislatures have specifically added lump sum payments to their child support laws. These laws mean that employers are required to report lump sum payments to those states, and when requested, to withhold from those payments. There is no consistency in the reporting requirements, such as threshold amounts, the method of reporting, or state response time. Some states with legislative authority to collect from lump sum payments have not issued regulations. Instead, employer instructions are provided online or in fact sheets, which is a little less than ideal for payroll departments, especially for purposes of tracking requirements or identifying legal authority in payroll records. New York has information on its child support webinar about reporting and withholding for lump sum payments. There's also an online calculator. State response time is not clearly identified, but hopefully when they do the session today on lump sum payments, you can gain more information. In states where legislatures have not identified lump sum payments in child support laws, state agencies may still include instructions or fact sheets on their websites. This can give the false impression that reporting and withholding are mandatory. It also creates a fairness issue if one employer reports and another does not. This past year, Payroll.org supported the Michigan and Washington child support agencies in preparing draft legislation to implement the model. Washington's bill, HB 1262, was signed by the governor this past May with an effective date of July. Unfortunately, Michigan's law did not pass, but we will expect them to try again. You might ask why it is that an association that represents payroll professionals would support this, because, as you well know, lump sum payments, the management of it is quite burdensome. So what we decided to do in collaborating on the model was to remain neutral, and we continue to remain neutral on whether a state should establish a program. Instead, because states were already issuing orders for lump sum payments and were moving forward with more programs, the best position was to try to get states to adopt processes and procedures that made the most sense for payroll, and to support states willing to listen to payroll professionals on those processes and procedures. Then there's the issue of withholding for independent contractors. Today, about 20 states and territories have either passed specific legislation enhancing their new hire reporting requirements to include the reporting of independent contractors, or they've issued regulations and guidance. Ohio was the latest state to pass legislation which will go into effect beginning on January 1st, 2024. Because a state requires reporting does not mean that a state is prepared to receive the information. That formal legislative authority requiring reporting has been given, or that a state has effective processes and procedures to manage withholding for independent contractors. There's no consistency in defining an independent contractor for purposes of child support. However, if an individual works for an independent contractor company, that company would manage the child support for that person. They are essentially an employee of the contractor company. Of course, as you all know, a contract does not necessarily define an individual as an employee or a contractor, nor do rules on providing Forms 1099. Yet, states often use these terms in their child support reporting requirements. For payroll, you're going to need an internal process to manage child support from independent contractors, because more likely than not, the individuals are being paid through accounts payable or some other department. And so when you get an order that comes in, you're going to have to make sure that you pass it on to the correct individuals working at your companies. This summer, we worked on creating a kind of a model law for best practices with clear definitions and to create some standardization among states like we had done with the lump sum payment model. In addition, the model includes suggested data elements, payment threshold amounts, and timeframes to report. The model also envisions reporting without employers specifying the full amount contractors will be paid. The threshold amount for reporting is $600, which is the same income amount required for reporting to the IRS. But note that New York has a threshold amount of $2,500. The state will consider a lesser amount if you report it. Unlike lump sum reporting, federal garnishment limits under the Consumer Credit Protection Act don't apply to independent contractors. A state could garnish 100% of payments made to independent contractors. Most do not have set state limits. Some have limits of 50%. New York is trying to follow the normal process involving the income withholding order for independent contractors. To date, the IWO does not have any unique elements for contractors, which adds to your need for internal processes. A revised IWO form is now in effect. However, to give states time to update their systems, OCSS has extended use of the current form until September 2024. The revised form does not include substantive changes to the information or processing. Form changes include decluttering the instructions by removing the Paperwork Reduction Act language. Other changes include an updated email for questions and highlights in the references for tribal child support agencies. The federal OCSS has an electronic IWO service. This system is not designed for making payments, but can be used when allowed by a state to receive IWOs and report lump sum payments and employee terminations. This can help with your automated payroll processes, and New York does allow the use of the IWO. The address of how you can access it or gain more information is on this slide. Finally, I'll offer you a quick note on future IWO considerations. Payroll.org offered OCSS some recommendations for off-cycle changes, such as a checkbox for independent contractors and instructions for calculating child support for employers with a daily pay period, such as for temporary agencies. Now, that's not earned wage access where you're paying employees prior to their regularly scheduled payday. This is a one-day pay period. We would also like to standardize the court and private attorney processes. Those are referred to as non-IVD orders. We'd like them to be able to use the IWO in order to have some consistency in the process. Thank you for listening, and to New York and New York City child support agencies for inviting me to speak.